Good evening. My name is Chris Diorio, and welcome to a special evening edition of ChrisChat. Normally, I do these from my office, but as you can see, I'm here in my home, figuring maybe that this might be a situation where I can get more people in on the discussion. What I want to discuss today is an issue that has come up, as many of you are aware, from your watching the news, reading the news regarding the incidents in Charlottesville over the past weekend related to Nazi organizations, white pride, white separatists, white whatever you want to call them, organizations that are attempting to have their views heard, and they're calling themselves constitutional originalists or constitutional separatists. What I want to discuss right now, based on what these events created over the course of this past weekend, and now discussion that perhaps these folks might be coming to here in Boston, where I am located or nearby, that perhaps it might be of some import to discuss what it is that they have the right to do and what they can't do. I want to break down the discussion today into two parts. First, I want to discuss a lot of what's happening related to discussions about let's stop these people from being able to talk. Why can't we suppress their speech? Why can't we revoke their permit for rallies? Why are they allowed to do this? So I want to talk a bit about what the Constitution says and what the Supreme Court has said regarding the First Amendment protections for individuals who speak in such a manner that they may, in fact, incite anger, but that's different constitutionally than inciting violence. So I want to talk about both of those. And secondly, I want to get into what a person's rights are as a protester. I'm going to flip this because it's a little disturbing to me. Thank you very much. I apologize for the aspect change all of a sudden. Wait a minute, I probably turned myself sideways. I can't do that. I apologize, folks. Oh. The second part of what I want to talk about is what your rights are as a counter-protester, and what their rights are in terms of their right to protest. Because much as we might not want this to be the case, there are circumstances where people are allowed to say certain things in certain forums. So I want to discuss what your rights are, what your protections are related to that. So first, backtracking to a discussion of the First Amendment related to protests and rallies and counter-protests and riots, and what the court refers to, the Supreme Court, as the Imminent Lawless action test. We'll step back first. Any of this type of speech, the first question you're asking is this taking place in what we know legally as a public forum? If you are in a private forum, you can be restricted with no recompense whatsoever. A private venue, a mall, or something of that nature can shut you down from speaking. In someone's home or a place of business or something of that nature, you can be shut down. That person controls, or that entity controls, your speech. But a public forum is something different. And there is a specific definition for it. A public forum is any property that has been opened up by a government entity, whether it's a city, state, town, what have you, opened up for use by the public as a place for expression. There's a caveat to that. Just because the public has access to it does not mean that it is a public forum. People have access to the mall. People have access to a variety of places. But just because the public can go there does not make it a public forum for purposes of protection. So Public forums are usually dictated, or as far as the law is concerned, historically, as being the public, what is known colloquially as the public square. Places like the Boston Common, places like in front of a courthouse, in front of a state or city or municipal building. These are all places that have been deemed historically to be public forums. And when you're dealing with a public forum, that's what triggers protections or lack of protection as it relates to the First Amendment. I want to talk about some of the historic aspects of what we're dealing with when we deal with public forum protests. And I do this because I want people to be aware when I hear folks, and a lot of them, talking about, well, we need to restrict these people's rights to speak. This is speech that we don't like, so we can't allow it. It's hateful. It's dangerous. It's violent. It's racist. It's bigoted. Any of the number of adjectives that we assign to these things. But historically, the First Amendment protects this type of speech and has protected speech that at the time was considered to be radical. Case in point, case of Edwards in 1963, segregation protests. The First Amendment was used and laws were drafted to stop people from doing things that were considered to be insightful. People protesting for their civil rights was deemed to be inciting violence. White people attacking black people, or other segregation protesters. In the Edwards case in 1963, there were segregation protests in front of a city building. And these folks were arrested. The United States Supreme Court said in the Edwards case that you can't make it illegal or criminal to utter unpopular views. It's hard for people to swallow that. I get that. I understand it. More recently, the case of Snyder versus Phelps. More specifically, if people remember this, Westboro Baptist Church protesting the funeral of a Marine who had returned home, Matthew Snyder. The Phelps family is the founding family of the Westboro Baptist Church, and they protest these funerals. And they went to this particular place near Baltimore, Maryland. They got a permit. They were located approximately 1,000 feet away from the church in an assigned area, and they carried their signs that say, God loves dead soldiers and God hate, and all of the hateful things that we've seen in the Westboro Baptist signage. And they were sued by the father of this dead Marine. And the case went to the United States Supreme Court, and in Snyder versus Phelps, the court reiterated a standard that we now have to abide by, in a sense, where they said that when an individual or a group is speaking on matters of public concern, and when they talked about public concern, they defined it very specifically as being a debate on a political issue, a social issue, or community-wide concerns. Whenever a group is basically talking about a matter of public concern as opposed to protesting on a specific or private or direct significant individual. If they had gone there and held up signs that said, we're glad Matthew Snyder is dead, Matthew Snyder was homosexual, Matthew Snyder, that's different. But these folks were out there talking about a general perspective, however wrong we believe this perspective may be, but they were issuing a manifesto, for want of a better term, about an issue of public concern, at least in their perspective on it. When you talk about issues of public concern, your speech is entitled to special protection by the First Amendment. Any type of debate on political, social, or community concerns should be uninhibited, robust, and wide open. And this is the very heart of why we have First Amendment protections. Speech should not be restricted simply because it upsets the listener or the viewer or arouses contempt, as this stuff in Charlottesville did. And yes, it was insightful in a sense. It incited anger, as this view should, to many, many people. But just because we don't like it doesn't mean we get to restrict it, at least as far as the Supreme Court is concerned. If there is a bedrock principle that underlies our First Amendment, it is that the government cannot prohibit the expression of an idea simply because society, in the majority or the vast majority, finds that idea itself to be offensive or disagreeable. We can't do that. You cannot restrict speech in that sense. Now, this is what's called content-based restrictions. And the Supreme Court says that you cannot restrict speech based solely on content. For the most part. We'll talk about some exceptions. So you can't restrict content of speech. But you can create what are called time, place, and manner restrictions. You cannot deny someone a permit to speak because you don't like what they're going to say. But there are ways to restrict that speech based on these time, place, and manner restrictions. There's a four-part test to this. You first ask, or is this regulation by the municipality or state or city serve an important government interest? Secondly, is that government interest served by the regulation? And is it unrelated to the suppression of a particular message? Very important. Is the regulation narrowly tailored to serve that government interest? And fourth, does that regulation leave alternative means for communicating the message? So if you deny a permit to somebody because of these content neutral restrictions, and there are many content neutral restrictions, when people talk about restricting your ability to leaflet in a place, when you restrict, you can have a rule that says you can't leaflet in certain areas and say that the reason why we're doing that is because we don't want there to be so much litter on the ground. That is a content-neutral way of limiting speech. And I'm going to issue a general apology right now for this less than confidence-inspiring mustache on my face right now. It'll be gone in 11 days, trust me. But so be it. So there are ways of restricting speech in terms of time, place, and manner. There are also some exceptions, and that's what a lot of people are throwing around right now in terms of how can we restrict a group or a person who is saying something that we don't necessarily like, that we don't agree with their opinion. Is there a way to stifle speech? And the short answer is sometimes. It's also a very vague answer, and I apologize, but I'll narrow it down in a second. What you should understand is that as great as this country has been, it is flawed. And one of the biggest flaws of this country is a seeming characteristic of American society that every once in a while, we are periodically gripped by fear. This fear is many times manipulated by politicians. As far back as the 1790s, French terrorists, were supposedly going to infiltrate the country. Abigail Adams wrote about it. The middle of the 19th century, there were warnings about the dire influence of immigrant Roman Catholics. And what do we do about them? After World War I, the genesis of what we now understand to be our First Amendment law related to speech in political forums. Many people talked about political radicals in the first Red Scare. That's right, the first. We've had more than one. But we always come back to is this. The First Amendment is meant to assure Americans that they can believe what they will and say what they believe, but repeatedly in times of fear, in times of stress, stoked by certain individuals and individual groups that manipulate and use this fear. Men and women have been hunted, humiliated, and punished for their words, their ideas, their thoughts, their beliefs. We look to our court system specifically the Supreme Court, to maintain our faithfulness in this freedom to speak. But courts historically have not always been consistent guarantors of our free speech, specifically when we're talking about insightful speech. David, I'm getting right to it. In 1918, we didn't have really any discussion in terms of Supreme Court precedent related to speech that was meant to incite, speech that was challenging. This stopped in 1918, right around the tail end of World War I. In August, there was a group of Russian immigrants who were arrested in New York City who were charged with violating the Sedition Act, which made it a crime to utter, print, write, or publish disloyal or profane or abusive language about the government, or to willfully urge, incite, or advocate any curtailment of things necessary or essential to the prosecution of the war. So basically, if you spoke out against the war, or if you spoke out against the government for prosecuting the war, you could be prosecuted for sedition. Now, these Russian immigrants in New York were arrested. Their crime was distributing pamphlets that criticized the United States military's deployment of troops into Russia. And they advocated in one of these pamphlets a general strike in military goods factories. This directly goes against the Sedition Act. So this group, among which a gentleman by the name of Jacob Abrams was a young anarchist, this group was tried and convicted and sentenced to prison for 15 to 20 years for distributing leaflets that were critical of the government and the war effort. Now, just before these guys got arrested and convicted, the United States Supreme Court had issued a couple of decisions dealing again with leafleting and anti-government hysteria. The principal among them, the case of Schenck versus the United States. And Justice Oliver Wendell Holmes wrote the decision in that Schenck case and created what we now know to be the clear and present danger test. Holmes said for him that in terms of speech that was inciting action, the deciding factor for him was whether the speech in question was of such a nature, I'm quoting him now, was of such a nature as to create a clear and present danger that the speech would bring about substantive evils that Congress had the right to prevent. That was the clear and present danger test. In essence, giving Congress the right to decide what was insightful speech in terms of questioning or being dangerous to the government. Now, this case was decided before Abrams. Abrams' case made it to the United States Supreme Court in the year following the creation of this clear and present danger test. And Oliver Wendell Holmes, the author of that test, when the Abrams case came to him, had a change of heart. It only took a summer for him to change his mind. But in that summer, he wrote one of the classic dissents, which now has led to our current jurisprudence related to speech that might incite potentially illegal activity. Holmes issued a dissent in the Abrams case. Abrams' conviction was upheld. But Holmes issued a decision, a dissenting decision that is as famous as any of the dissents that we have in modern Supreme Court jurisprudence. He said that he still believed that he was right in that Schenck decision, but he modified his test. And the test modification is very key for what we know now to be our test. He said in his dissent that the government could restrict and punish speech that produces or is, and again quoting, that produces or is intended to produce clear and imminent danger that it will bring about forthwith substantive evils. The keys there, two words. One, imminent. He used the word imminent in discussing the present and adding another qualifier, forthwith. The speech that we're talking about prosecuting or punishing has to have a danger of imminent action that will be done forthwith, not down the road, not a week from now, not a month from now, not a year from now. The speech that we're talking about is going to incite danger now. Definition of forthwith, now. Holmes, by doing this, created a much stricter standard for judicial scrutiny in these areas. Only when a direct and immediate connection between an act of speech and a subsequent crime existed could the speech itself be criminalized. Holmes talked about Abrams in this dissent and said that the publishing of again, quoting him because he's brilliant, the surreptitious publishing of a silly leaflet by an unknown man would not possibly present any immediate danger. And he argued then for the social benefits of unrestrained free speech. And he talked about the free market of ideas and how ideas should be allowed to be presented into the marketplace and let truth will out. He said the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which these wishes safely can be carried out. And at least that's what we should be looking for in terms of what our constitutional standard is. Now, over the course of the next 50 years or so after Abrams was decided and after his decision or his dissent in Abrams, we had a number of other cases. One dealing in 1937 with a gentleman by the name of Angelo Herndon, who was an African-American male who was a Communist Party organizer in Georgia. You want to talk about balls? That's balls. A black man in Georgia organizing for the Communist Party. He was convicted of attempting to incite insurrection in violation of Georgia law because he was doing what he did. And the United States Supreme Court decided in favor of Herndon at that point in a 5-4 decision, signaling that they were starting to move away from this clear and present danger test. We get to a point in 1943 where in West Virginia Board of Education versus Barnett, dealing with the compulsory making students salute the American flag in the morning, Justice Jackson, and this is sort of separate from where we're talking about, but his quote here is important. Compulsory unification of opinion achieves only the unanimity of the graveyard. Again, classic prose in Supreme Court decisions. It seems trite, but the First Amendment is designed to avoid these ends by avoiding these beginnings. We can have intellectual individualism. We can have a rich cultural diversity that we owe to exceptional minds, only at the price of the occasional eccentric, the occasional abnormal attitude, something that's not the norm. Freedom to differ is not limited to things that don't matter a lot. Freedom to differ, that's a shadow freedom, that's a chimera. The test of the real test of the First Amendment is the right to differ about things that touch the heart of our existing order. Quoting from Jackson, if there is any fixed star in our constitutional constellation, it is that no official can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Talking about forced pledge of allegiance. But again, the language there is terribly important regarding the unanimity of opinion and the value of conflicting ideas, however heinous, the value of conflicting ideas in the public marketplace. Jackson's point there is that the First Amendment doesn't allow the state to compel speech, but it can and should allow for speech to be presented in the public marketplace. Again, hearkening back to Holmes. Which brings us now to our current standard. And you may have seen this on multiple websites and memes and things of that nature, but I want to talk to you very specifically about what this case means. You may have seen a case titled Brandenburg versus Ohio. In 1969, the Supreme Court created a new test based on what Holmes had written over 50 years before in this Brandenburg versus Ohio case. Brandenburg was a Ku Klux Klan leader who, at a rally, had denounced, as many Ku Klux Klan leaders are wont to do, denounced blacks and Jews with burning crosses behind him. And he had actually brought the news media there. Reporters were there. Video film was done. Brandenburg is seen in the films saying about the Klan in Ohio, "We are not a revengeant organization." That's not a real word. But if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it is possible that there might have to be some revengeance taken. Again, that's not a real word. We'll leave that aside. Sound familiar? Sound familiar? Here is a white supremacist talking about the government and revenge or revengeance, but we understand what he's meaning. He's talking about anger with burning crosses behind him and men who are armed. Sound familiar? Another film at this same time had Brandenburg saying, and I apologize for using the word, but I'm quoting him directly. "Personally, I believe the nigger should be returned to Africa and the Jew returned to Israel." Sound familiar? It should. I heard a lot of it just recently. Now, Brandenburg was prosecuted on a criminal syndicalism statute in Ohio that restricted his ability to say these types of things. But the United States Supreme Court created a test in a decision that had no author. Well, it had an author, but the court, the entirety of the court, agreed to this decision. In reversing Brandenburg's conviction, the Ku Klux Klan leader who gave that speech created what we now know to be as the Imminent Lawless action test. The Supreme Court held that the First Amendment will only punish subversive advocacy that is calculated to produce imminent lawless action and which is likely to produce such action. Two parts of the test. Brandenburg took what Holmes had said previously about clear and present danger and mushed it together, sorry for the technical term, with the imminent action that he discussed in his dissent. This is now the test. There has to be, one, imminent lawless action, and secondly, the speech has to be likely to produce it. It's a hard standard. It might not seem like it. You might look at the speech that we're talking about now in Charlottesville and maybe what happens in Boston and other liberal cities, which is where these folks are going, by the way. They're coming to us. And I am a liberal. I acknowledge it. But I also know what the Constitution says. I'm not here to reinterpret it for you. I'm here to tell you what it says. And this test right now is a hard one to prosecute. They went on in this decision to say the mere abstract teaching of the moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and stealing it to that action. I apologize. I'm having to relocate myself here. I'm losing power on my phone. I apologize. Sorry for the break in the action. So again, when you're talking about this speech, you cannot suppress it simply because it talks about a resort to force and violence. That is different than actually preparing a group for violent action and stealing it to such action, to use the terms in the case. Right? I understand that it's a hard one to listen to, it's a hard one to acknowledge, but that is the test. Imminent lawless action and likely to incur that action. Right? The court applied this test multiple times, and it is an extremely rare situation where the United States Supreme Court has looked at prosecutions and allowed the speech to be suppressed. Specific Hess versus Indiana being a case, reversing the conviction of a demonstrator who told a police officer, "We'll take this fucking street later after you're gone." Sounds, it's a plan, right? But the court said in that case that Hess's statement taken at that moment was not aimed at producing imminent lawless conduct, but rather lawless conduct at an indefinite future time. So these people can talk about white power this and, blacks go home and all this garbage that they spew. They can talk about it, but until they're actually saying, go do it and here's the axe, here's the bat, here's the fire, that's not restricted. So we have this Brandenburg test. To pass constitutional muster, a conviction must be for advocacy that is A, directed to inciting or producing imminent lawless action, and 2, that speech is likely to produce such action. The first part of that test deals with the persons who is speaking or the persons, their intent. What is their intent? To incite imminent lawless action. It's hard to prove. It's a hard test. The second test, that imminent aspect of it, is very difficult to handle as well. What we fail to acknowledge too often, because speech like this makes us emotional. It does. Makes me emotional. I don't like this message. I don't like what these people are saying. The vast majority of people don't like what these people are saying. It is incitement. I get it. But here's the thing. Every idea is an incitement. Every idea that is proposed offers itself for belief, and if it's believed, it gets acted on unless another belief outweighs it, or by some failure of its own energy and ability to generate strength behind it, stifles the movement before it even gets out of the birth canal. The only difference between the expression of an opinion or an idea and an incitement to violence in the narrower sense is the speaker's enthusiasm for the result. Eloquence may set fire to reason, but whatever may be thought of the discourse and the absence of solid or sane discourse, if in the long run the beliefs expressed are destined to be accepted by the dominant forces in a community, the only meaning of free speech is that they should be given a chance and have their way. What we see here now is a desire to, like the way religion makes people upset in certain ways, patriotism does the same thing. It is an indispensable virtue. It is exalted, but if it's excessive, fanatical, it becomes reprehensible. The same way people who throw their religion in your face can have a reprehensible tendency about them. Right? You look to Holmes and talking about the marketplace of ideas, and he took directly, it seems, from John Milton, who talked about in his Areopagitica the idea or notion of conflicting ideas. And though all the winds of doctrine were let loose to play upon the earth, so truth be in the field, we do injuriously by licensing and prohibiting to misdoubt her strength. Let her and falsehood grapple. Whoever knew truth put to the worse in a free and open encounter. Truth will out. Truth will out. But if we simply restrict ourselves and restrict speech just to the speech we like, why have a protection for speech at all? Why have it at all? It's unnecessary. That's the standard. If you have questions, by all means, post them up. I'd love to hear, if you have questions about what I'm talking about, by all means, get them in. But what I want to talk about now is the second part of what we discussed. And I'll go through it quickly because there are protests that are being planned. There's what they're calling a rally, what many people would call a riot, planned in Boston on the Boston Common this week. And there are counter-protesters that are also rallying because that's what you're supposed to do in a situation where you don't like speech. You don't suppress it because you don't like it. You don't simply make it go away. You do, however, speak against it. You, on one corner, yell at the top of your voice to shout down a viewpoint that the other person is going to raise themselves to the top of their voice to speak against you. So I want to go into, right now, general guidelines about protests. I've done ChrisChats about this before, but I want to talk specifically and remind people now what this all means, what your rights are, and how you protect yourself come Saturday. And in the future, if something happens down the road. First, in terms of the speech itself, can your speech be restricted because of what you say, even if it's controversial? And as I just talked about, no. The First Amendment prohibits restrictions based on the content. They can restrict where you speak. They can restrict when you speak. They can put time, place, and manner restrictions on you. But they cannot address or stifle the content of your speech. The Constitution doesn't protect everything. There is no absolute right. There is none. None of these rights in the Bill of Rights are absolutes at all. First Amendment's pretty close, but there are no absolutes. There are restrictions. All right? The police are allowed to place certain non-discriminatory and narrowly drawn time, place, and manner restrictions on you, but very narrow. Where can this speech occur? As we talked about at the beginning, public forums. All types of expression are constitutionally protected in what we know to be traditional public forums. Sidewalks, streets, parks, the Boston Common, the front of a city or state building in Beacon Hill or wherever. Your speech can be permitted to take place at other public locations if the government opens it up for that. You can't do it on private property. Free speech cannot take place on private property without the owner's consent. If the owner does not want you there, if the owner wants to restrict you or tell you to get out, you must get out. Massachusetts has a few limits on that. Large shopping malls, you're allowed to go in and do certain things, but they generally only apply to collecting signatures for elections. Do you need a permit before engaging in a demonstration? Actually, no. You don't necessarily need a permit. If it's really big, then yes. A march or a parade that doesn't stay on a sidewalk or other type of events that require police protection or blocking off traffic or street closures, that usually requires a permit. Any large rally that requires the use of a sound amplifying device requires a permit. Rallies at designated parks, such as the Boston Common, require a permit. And these things that are happening allegedly on Saturday will need a permit. As I understand it right now, a permit hasn't been issued for the folks that are coming in. What can you do at these places? there's a lot of discretion that's given to the police or to local officials to impose conditions, such as route conditions, such as how loud it can be. A question: can you shout, "Punch the Nazis"? I would walk that back and use the same test as would be used in the imminent lawless action test. If you're inciting a violent act, and it's likely that that lawless act is going to happen, then that might be a prosecutable offense. That might be prosecutable speech. But again, it's one of those situations, and it's hard to say when you look at this, that you almost have to wait for the punch to be thrown, which is a sad state of affairs, and too often happens that you sort of have to wait to see, because it's not necessarily likely that someone will throw a punch. Right now, in this political climate, in this particular climate, you might have a case that shouting "punch the Nazis" could be considered to be inciting imminent lawless action if it's likely that that lawless action is going to occur imminently, right then. So I think maybe more like, yeah, I think that it's possible, especially given, as I said, the climate that we're in right now. It's an incitement to violence, and if it's likely to result in a lawless act, then so be it. That is technically something that could be prosecuted. As we talked about, there's a lot of specific restrictions and control given to local law enforcement. The bottom line is, though, you can't deny a permit to any of these groups because there's the possibility of a controversial statement that's going to be made, or if the views are unpopular. So the discussion that we're having as far as Mayor Walsh saying we're going to do whatever we can to keep you out of here, I think he should have some folks up in his office in the legal department chirping in his ear right now, because any number of groups could go in there and protest and have a rally if they are speaking with a voice that he likes. But if it's these folks and he wants to hold them down and keep them out, I think he's going to have his own problems there. You can, if you're going up there and you have signage, you can raise signage. You just can't leave leaflets on the ground. You can't do certain things because that's violating other particular ordinances and statutes. You can picket on public sidewalks as long as you are not impeding traffic. It has to be done in an orderly, non-disruptive fashion, and you have to allow pedestrians that are not involved in the rally or protest or demonstration to pass. You also cannot block entrances to buildings, so there should be gaps in your line. Can the government enact a financial charge? Can they charge you for a permit? Yes, they can. But it has to be equal for everybody. There were certain cases a while ago, Supreme Court dealt with these, where they said that the amount of the fee or to have the permit was based on the amount of police that it was anticipated that you would need, based on the speech. So basically it was like a heckler's veto that, if there were a lot of people that were going to show up and create potential for harassment there, then you would require more police, and therefore it costs more for you to speak than it would for somebody else to have a rally about breast cancer, because there's not a whole lot of protesters related to breast cancer, but these folks who are coming up from God knows where, there's going to be some counter protesters. So a big question that's been asked a lot recently: do counter protesters have free speech rights? Yes, obviously they do. But here's the line, and this is what happened in Virginia, and I hope to God and to all reason that this does not happen here. And it goes back to that whole punch the Nazis thing. Counter protesters should not be allowed to physically disrupt the event they're protesting. They have a right to be present. They have a right to voice their displeasure with the people who are speaking and what the message is. The police are allowed to keep these two groups apart, and they should do that, but they have to keep them apart, but they should allow them to be within the general vicinity of one another. So there is that restriction there. Once you step into the area of violence, that's when the First Amendment goes out the window. You're no longer talking about protecting your First Amendment rights to protest. When you throw a punch is not speech. A punch is a crime. Right? Question. Assume a Nazi is a public employee, say for the University of Massachusetts. Can the University of Massachusetts fire the Nazi for speaking? There are specific restrictions that deal with public employees and whether they have First Amendment protections. The rule, as I understand it generally, is that if you are speaking in your role or in your capacity as an employee of the university, then you are in danger. But if you are not speaking in your role or in a representative fashion for the university, it's less likely that you would have any type of punishment or should have any punishment levied on you. The problem there is they're going to go ahead and fire you, and then you're going to be fighting for a couple of years to get, whatever happens there, and it's a harder case because of what's happening. But there is a line that's drawn when you're talking about public employees and their First Amendment rights, and whether they can be protected for speaking or doing certain things or exercising their First Amendment rights. If you have a situation where you are engaged with police or law enforcement during a protest, it doesn't do you any good to argue with them. Talk to a supervising officer, explain your position, point out that you're not disrupting anybody else's activity. The First Amendment protects what you're doing. If you don't obey that officer, you could be arrested and taken from the scene, and there goes your protest. There goes your demonstration. You shouldn't be convicted unless a court concludes that your First Amendment rights have been violated. So if there are any questions, any other questions related to this, I'd be happy to get into them now. But that's all I have. If you do have other questions, you can post them here. I will address them after I shut this down. I'll sit here for a bit and see if there are any questions that come up. Just recognize that you don't have to like what these folks are saying. You're not being compelled to listen. But if you do, you don't get to shut them up by making them go away. That's not what we are. That's not what this country is. We don't suppress ideas. We don't suppress thoughts. We don't suppress speech unless it violates one of these specific exceptions. The First Amendment says no law. And it means no law. I believe in a great respect that, that as Justice Hugo Black did, that, no law means no law when it comes to certain types of speech. You have to address that we are different, that we have a different perspective on the world, that we are in a time where we are challenged and we are called to that challenge. And the views expressed by these individuals are not and should not be shared, at least as far as I'm concerned, by right-minded individuals. I just what I don't want to happen is for us, on the folks that want to close these folks down, to become them. The restrictions that I looked at a post the other day where it talked about, I think the First Amendment and freedom of speech has become dangerous. You know what? You bet your ass it's dangerous. It's supposed to be. It's supposed to be dangerous. If we didn't allow for that, if we didn't speak up against the government, if we didn't demonstrate, there wouldn't be tea in the harbor 250 years ago. If we didn't speak up and demonstrate, we don't have the civil rights movement. Stand up to these ideas, yes. But not by knocking them down. Because at some point or another, there is the possibility that these same restrictions that you want to put into place to suppress this speech that you find to be heinous could be used against you. When your views are deemed to be heinous, when your views are deemed to be out of the mainstream. Do not create bad precedent by suppressing speech. Because the speech and the law that you create now may be the hammer that beats you down later on. It was this same idea of suppressing insurrection activity, which is what J. Edgar Hoover referred to the civil rights movement as insurrection activity. And he moved to suppress that speech, to stifle the ability of civil rights activists to do what they did to assert and grab for the rights that they were entitled to. If we allowed for speech to be suppressed then, we would not have what we have now, such as it is. The bill has not yet been paid. Question: when exactly is hate speech illegal? Does a threat need to be present? I've talked about hate speech in the past, and I'm gonna say something. I'm gonna say something controversial. I'm very much against hate crimes laws. I think that when you start judging people for their thoughts and not their actions, when you start basing punishments on thoughts and motivations as opposed to the actions that they commit, I think we're going down a dangerous road. When does hate speech become prosecutable? When it becomes hate action. You can talk about the cross-burning cases and things of that nature. You're allowed to burn a cross the same way every year I burn a flag, which offends countless people. And yet you burn a cross and it has a similar effect that creates bile that comes up into your gullet. But it's allowed in certain respects. Unless the action is a direct threat to the individual upon whom you're burning the cross on their lawn, that's a crime. But if you're simply burning a cross in a demonstration, that's permissible. It's symbolic expression. So hate speech is a difficult line. It's probably something that I'm going to have to come back to. And Doc, thank you very much for raising the question. And perhaps I can do a ChrisChat very soon about the whole notion of hate speech and symbolic expression, because it does come up here. What we're talking about, though, I would think, is the notion that a flag or a swastika is in and of itself an incitement to violence. It's not. Yes, it engenders hatred. Yes, it engenders anger, but the mere existence of this symbol is not a call to arms. It is not a call to violence. Yes, it represents violence. But I'll tell you this, the American flag in many parts of the world is just as insightful as that flag. I don't like saying it, but it's true. In countless countries around the world, the American flag engenders just as much bile and hatred and violence as that swastika on that red and white background. When you look to suppress that kind of activity as being insightful to anger, we do need to take a look at ourselves. We cannot allow ourselves in this time to become them. If there are no further questions, I will adjourn. If you have questions, you leave them here. I will answer them on the video. I will post this as soon as I shut down. I will post this to be viewed later on for those who wish to view it. Again, as always, thank you very much for stopping by. If you have not gotten from me your copy of the United States Constitution, I will, as I have for months now, through ChrisChat, I will send you your own pocket version of the U.S. Constitution and all of its amendments. I will send it to you free of charge. Knowledge is the true superpower. Have this with you at all times. It is the essential rule book. All you have to do is send me a message and I will get a Constitution into your hands. If you are a teacher and you want them for your students, I will send them to you. I've got boxes of 50 and 100 going out to schools all over New England and outside of New England. If you want them, I will get them to you, again, free of charge. All right? It's that important, especially now. Thank you very much, ladies and gentlemen. My name is Christopher Diorio, and this has been ChrisChat.